Stiftung. Thank you very much for setting it up. Thanks to the speaker, and I'm looking very much forward to the discussion.
Thank you very much, Henning, for those opening words. And again, we thank CUS for your support. The seminar, just some preliminary words about how we will conduct it. It will be done as a panel discussion, with each of the panelists addressing from the perspective of their jurisdiction a number of questions. We are also, as I mentioned, streaming live on Facebook and hope to make it available online later. Those on Facebook who are RSVP'd, as I've mentioned, you have the opportunity to send it to the email address you were provided with. So please, you feel free to participate. We request you please to keep yourself muted and, as I said, off video apart from the presenters. And if you wish to ask a question, you can pose a question in the chat section or simply put your name there and I will enable you to ask your question in the question time. Okay, so that's how we will run this and hopefully have an exciting discussion. So without further ado, we're going to commence and I'm going to ask the first question and I'm going to ask Professor Manuel Cepeda to start. Under which constitutional structures, Manuel, have lockdowns been declared in Colombia? Was it a state of emergency, legislation, and what checks and balances are in place to ensure power is not abused? Given that global South democracies more generally remain fragile, did authoritarian tendencies display themselves in the Colombian response, or was it in fact wholly within the structures of the constitution?
Thank you, David. Well, we in Colombia, as you know, we had several problems, crises, armed conflict, extreme poverty, emergencies of all kinds. So Colombia is a country of emergencies and problems. So we have in the constitution a special provisions for states of exception. For this pandemic, the key instrument has been the state of economic and social emergency. So the Constitution allows for the president to legislate not only for economic matters, but also for social matters in an emergency. Nevertheless, the pandemic has led to a huge constitutional debate because the initial declaration of the sanitary emergency was not done through the states of exception provisions of the Constitution, but by the Ministry of Health invoking legislation that was not clearly authorizing such massive restrictions of basic liberties as social distancing, for example. And therefore, there is a huge debate in Colombia on how the system of checks and balances will work. Under states of exception constitutional provisions, the checks and balances are clearly stated in the Constitution. The president may declare the emergency, needs the signature of all the ministers of the cabinet, then the decrees should be sent both to Congress and to the Constitutional Court for automatic judicial review by the Constitutional Court in a shorter time, and the political control by the legislature implies two things: a debate on whether the emergency was adequately and conveniently declared, and secondly, a modification or derogation of the measures adopted by the executive. And so Congress is totally enabled to overrule, let's say, the president in the legislative decrees adopted by the president to handle the emergency. And on the other hand, the Constitutional Court can render decisions both on the decree that declares the emergency and the decrees that develop the emergency. The decree that declares the emergency was, before the 1999 Constitution, considered a decree that was outside the realm of judicial review, a kind of political questions doctrine, although we didn't use this word, but kind of political questions doctrine was operating. In 1991, this was changed, and the Constitutional Court held that it could review the decree that declares the emergency. And a few weeks ago, the Constitutional Court rendered her decision on this decree and held that it was constitutional, applying the criteria usually used. These criteria are of two kinds. First, factual analysis. The government has the burden of proof that the facts invoked to justify the emergency, according to the Constitution and statutory law that regulates this institution, were true. It has to prove the facts. And there the court applies a strict control, and if the facts are not proven, the emergency in total or in part is stricken down. It has happened in the past. The court has stricken down states of exception declarations. The second aspect of the control is whether the political judgment concerning the gravity of the facts is compatible with the constitutional limitations. And there the court applies like the doctrine of margin of appreciation. The court says, okay, the president has a wide margin of appreciation to determine whether this was really very grave and the president needed to legislate. But there are two limits. Cannot be arbitrary, and there cannot be a manifest error of appreciation. And this, the court has used it in the past to some occasions, also strike down states of exception. The second aspect of the judgment of evaluation is whether the president justified adequately that the ordinary means were not sufficient to address the emergency. Because if ordinary legislation allows for handling the emergency, the state of exception cannot be used. And so there again, the court applies margin of appreciation with the limits of arbitrariness and manifest error. The problem here, to conclude, is that the emergency, since it was sanitary, was declared by the Ministry of Health through an administrative act, and then developed by the President and the Ministry of Health and the Ministry of Interior through administrative decrees. So the court had to decide whether these administrative acts were also under the jurisdiction of the court, even though they were adopted previous to the declaration of the state of emergency. And therefore, the court divided on the topic, divided on the issue, and held that these administrative acts had to be controlled by the Council of the State, as is expressly stated, let's say, in the Constitution and in the administrative code, and therefore the court abstained to review these administrative acts. And we are pending the decisions of the Council of the State concerning these acts. This is briefly how the system of checks and balances is on. The other question, has there been authoritarian tendencies? I don't think so. Although the measures have been very restrictive, I would say that the government has worked in the interest of protecting the citizens. And this has been both the rhetoric and the content of the measures. Nevertheless, the restrictions of rights have been high, very high. And secondly, there has been recently debates about the constitutionality of these measures, but this we can address afterwards. And so I stop there, not to take too much time, to set the framework of our conversation. Thank you, David.
Thank you very much, Manuel. And that's really interesting about the actual constitutional challenge that has been heard in Colombia around the actual declaration. And so perhaps let's turn to South Africa to hear about, Sandy, what has been the structures through which South Africa has implemented. There are some similarities there, has implemented this, the state of disaster, and how has that proceeded, and have there been authoritarian tendencies as well demonstrated? Colombia seems to have been quite good in that respect.
Thanks, David, and thank you to everyone for participating in our webinar. So just to make a disclaimer, I speak here in my academic capacity and not as a member of the committee. So just to clarify, South Africa has declared a state of national disaster in terms of ordinary legislation, the National Disaster Act of 2002. Now, this piece of legislation, so it hasn't, and this is a really important point, invoked the state of emergency in terms of Section 37 of the Constitution, which permits declarations of a state of emergency and a derogation from the Bill of Rights subject to certain conditions. Now, this National Disaster Act has two features. Firstly, it has a very broad definition of what constitutes a national disaster, which includes any sudden or progressive event which can endanger life or property or disrupt the community, and which the ordinary capacity exceeds the ordinary capacity of the community to deal with. Once a state of disaster is declared, the Minister of Cooperative Governance and Traditional Affairs is given wide-ranging powers to make regulations and directives in order to cope with the declaration of the state of emergency. And she can also authorize other ministers to make declarations. So it is essentially in terms of this piece of ordinary legislation that South Africa has imposed what is regarded as one of the strictest lockdowns in the world under our 5-phase alert level risk-adjusted strategy, essentially starting from the 26th of March until the end of April. We've been operating under almost total shutdown of business activities and stay-at-home orders, essentially with limited exceptions. Our military has been deployed to enforce the lockdown. And during the course of May, we moved to level 4, a slightly adjusted level, but still with quite far-reaching measures, restrictions on businesses. A nighttime curfew was imposed, restrictions on exercise times to a limited window of time, and a complete prohibition on the sale of nicotine products and alcohol. Since 1 June, we are at alert level 3, with an opening up of the economy subject to strict conditions, a phased reopening of our schools and higher education institutions, as well as places of worship. What is interesting about South Africa is, unlike many other jurisdictions, we are busy lightening our lockdown just as our cases are rapidly escalating. So we have now hit the benchmark of over 50,000 active cases, and we have just passed 1,000 deaths this week. So, and the virus is predicted to peak probably in July, August this year. So we are, in fact, due to the consequences of this hard lockdown, actually going towards a more lenient lockdown regime. Now, for the purposes of this segment, I'll highlight 2 issues that I think are particularly important from a checks and balances point of view, and I want to deal with the authoritarian tendencies when we come to speak about civil and political rights. So the first issue under the checks and balances that I would highlight is the dilution of the role of the legislature, the national parliament. So one of the ironies of using this national legislation is that after the initial 3-month period, the minister can extend the state of disaster for 1-month periods at a time. And this is in fact what has happened, where we have had it extended now to 15th of July. Whereas if we had declared a state of emergency under Section 37 of the Constitution, Parliament would have been given a much greater role. After an initial short period of executive action, Parliament would have had to authorize by a greater majority, initially 50% and then 60%, further extensions of the state of disaster. So essentially, we have had far-reaching restrictions to fundamental rights, movement, religion, trade, etc., imposed essentially through a series of executive rulemaking rather than through the elected representatives of the people and all the public participation requirements that go with it. Another aspect that I will just highlight in conclusion under this segment is that there has been a lot of concern expressed about a body called the National Coronavirus Control Council, which has been set up as a coordinating structure for dealing with all aspects of the coronavirus pandemic. Its backbone is essentially the National Joint Intelligence Structure, so it is dominated, as I understand it, by police and military officials. And it's not really clear who sits on this body. The minutes of the meetings are not public of this body, and it is unclear at the moment whether its role is purely advisory and coordinating, or whether, as some decisions seem to suggest, it also has a decision-making role which should properly be reserved to cabinet as opposed to some other structure set up. And I think this has given rise to a lot of debate in South Africa regarding its role in the traditional system of checks and balances. So David, I'll leave it at that for now and come back to the authoritarian issues when we talk about civil and political rights. Thank you.
Thanks, Sandy, and for outlining the South African situation. And actually, I attended a Zoom seminar the other day on the African position, and it seems very similar that there have been essentially the use of state of emergency measures without the declaration of states of emergency. Amita, do you want to tell us about what's happened in India? Has a similar pattern emerged in India? Yes. Under what structures have these things happened? We saw a very severe impact happening in India and a rising pandemic, and also perhaps the authoritarian question, if you want to address it now or later. Thank you.
Thank you, David. I suppose, I would say that the choices they made in India are kind of very similar to what my colleagues from Colombia and South Africa are saying, in the sense that the Constitution of India also has provisions for declaration of emergency, both for internal and external purposes, as well as a financial emergency. But there is also, because we've had one experience of an internal emergency, a lot of you could say, precautions came into the Constitution to sort of prevent any kind of misuse. And most importantly, what did come was that even in a state of emergency, the right to life and liberty cannot be suspended. And evidently, procedurally too, the emergency route requires, it has to go through Parliament, it can be subject to judicial review. You know, the entire meta conversation is of a very different order. Whereas I would say what we have done in India, I mean, at one level, I would even describe it as a constitution as spectacle, in the sense that for us, our entire lockdown process came firstly from a speech of the Prime Minister, which was then followed up by a notification which came in under we have a Disaster Management Act, and it was primarily that act which was used, that act in combination with the Epidemic Diseases Act of 1897. You know, it's like, because we hadn't really updated that statute, and that statute provided for that if you require for the better prevention of the spread of dangerous epidemic diseases, you know, and the ordinary law is insufficient, you can do, like the state can do whatever it seems or deems fit. The Prime Minister announced a 21-day lockdown, and the Disaster Management Authority came up with what it called the social distancing guidelines. And in the social distancing guidelines, you came up with, because we started from absolutely like saying, okay, fine, nobody just stirs out of home, you know, and within a space of 4 hours, you required, because the Prime Minister made his speech at 8 in the evening, and from midnight, the entire set of restrictions were to come into place. So people were not really given time to sort of adjust to this entire, you know, the fact that even basic things like that, if you have a home, you still need to be making provisions for what you would, you know, when you eat and drink and stuff like that. Your basic essentials to kind of store in, you were not really given time. Also, somewhere in this entire thing, we kind of forgot, and I think I would be speaking much more on that in the subsequent part of the webinar, on the diversity existing within the country, and that everybody was not at the same place. So when you're talking in terms of a lockdown, it did not impact on everyone in the same manner. And the arrangement of that lockdown, or the announcement of that lockdown, did not really take it into account. So you were told you have to stay at home, presuming everybody has a home, presuming everybody has essentials, everybody's kind of, you know, so all that you need to do is your freedom of movement is being curtailed for the greater good, for your own good, for the fact that this is the only way in which we can curb this major pandemic, is because we have to, you know, like break the chain, as was being said. And the only way in which breaking the chain is if we are not having interaction. The second point, so it's like again, like what has been spoken by the other speakers, it was a kind of executive orders, you could say, through which you kind of imposed the most intensive kind of an emergency. So and the other thing which is important to note is that nobody was asking the constitutional question. No one was saying that, listen, if you are imposing this kind of an intensive lockdown, what happens to my fundamental rights? It was just taken for that this is something, these are rights we should all voluntarily give up in order for the greater good, you know. And there was when we started out, there was a fair amount of consensus on this point that, you know, it's stupid to be saying freedom of movement or liberty or moving out and all the kinds of rights which were being curbed, because if you want to die, then you go ask for it, kind of things. You know, that was the way in which the discourse happened. Some people did move the Supreme Court of the country in relation to more, you know, the people who were hard hit by. But the court took the line that this is a policy matter. This is also a kind of a medical matter, or a health matter, a technical matter. We are not really equipped to deal with it. And we should not enter into these kind of quibbles and hence curtail the effectiveness of the government to do what is good for the people. So it was like judicial review is our major check on both executive as well as the legislature. So you were not asking questions like that, are these regulations in conformity with fundamental rights? We have a provision in our constitution which says any law policy made against the fundamental rights is to that extent, is void, is bad law and all of that. Nobody was asking those questions. The court took a hands-off attitude and said, no, we have to totally strengthen the government in its task. The third thing which I feel is important from a constitutional dimension and from the check and balance aspect is you could say we have what is often called as a quasi-federal structure. But it's our federalism which brought in the kind of diversity of approach. And you suddenly found that every state government did not address the matter in the same manner. And it also became like Kerala for us, which is one of our southern states, with highest literacy rate, a really good, strong social sector, handled the pandemic in a very different way from what was done in other parts of the country. So when I look at your authoritarianism thing, it is like it didn't play out the same way everywhere. The center made this kind of grand statement, did not really say, okay, what will happen to people who are not, who don't have the point which the introducing speaker made, where you don't have that level of, financial security. What are you going to do? People who are daily wagers, people who if they don't go out to work, they don't eat, what happens to them was something which wasn't addressed. But in Kerala's case, they worked that entire thing out in a very neat manner. They worked out both the testing, the quarantining, the whole business of who is deserving of what. So it's in the same country, you can say, we got very different kinds of models operating. Wherever you had a deep, good, strong health system coupled with, the sort of social security that you require, the pandemic got addressed in one kind of manner. People did not feel wronged. They did not feel that, oh my God, what's happening? They just felt that they had to join hands with the government. That isn't what happened elsewhere. And on the check balance thing, because the parliament wasn't functioning, it was also locked down. The court said, we don't want to do anything. So it basically became an executive show. I think for the present, I would say this much.
Thank you very much, Amita. And I think we already see some emerging themes. And one thing that seems to have been quite common is the way in which state of emergency structures in constitutions have been bypassed, and effectively states of emergency have been put in place without those particular provisions being utilized. And I think that's a really important thing for constitutional lawyers to grapple with. What is happening there? Is this a grab simply for executive power? Or is it that perhaps some of those constitutional structures are not adept enough to address crises like this, and we need to think carefully about how often they weren't thought about in the context of health crisis per se? And perhaps there are some differences that we need to consider there. I want to move across. Amita, you also mentioned, I'm just going to put in parenthesis, federalism and the responses. That's actually a very interesting issue. And I think you've seen this in the United States, in Germany, and various other places. And that would be in itself, I think, quite an interesting seminar to have. But I want to move to the question of civil and political rights, obviously, which are themselves have been affected in many cases. And one of the important questions for constitutional lawyers is whether or not the least restrictive measures have been placed on civil and political rights when imposing social distancing requirements. So most people would accept that there's a legitimate purpose to try and address a serious health crisis and to save lives. But were those measures least restrictive, or at least minimally restrictive, or were they in fact, was there wholesale violations of rights which were not really necessary? And in relation to that, there's a question about, were there some constitutional challenges, and to what extent were they successful? And here I would like to start with Sandy Liebenberg to tell us about the situation in South Africa. Sandy, I need to unmute you. Sorry, it seems to have, I need to unmute you again. There we go. Can you unmute? Yeah.
Good, thanks, David. So the irony now is, because we're not operating under a state of emergency, in theory, all limitations to fundamental rights would have to pass the proportionality, the purpose and the proportionality test under our general limitation clause, which includes, as you mentioned, David, less restrictive means, but also whether there is a rational relationship between the measure and its purpose and the nature and extent of the limitation. Now, the problem is because many of these restrictions were imposed through executive actions, regulations, and directives, the deliberative process that one would normally have in a parliamentary process of determining what kind of factors informed the limitation of rights is not evident to the public. So it's not very clear, you know, sort of were rights taken into account, were less restrictive means, why was a particular measure deemed necessary? And although during the hard lockdown initial period, this enjoyed widespread support and people generally accepted that this was necessary for combating the pandemic, as we've gradually loosened restrictions and some businesses have been allowed to open and not others, and some relief measures have been granted and not others, there's been an increasing debate about the rationality as well as the compliance of the limitations with the proportionality test. And only last week, there was a challenge to the rationality of the level 4 regulations in the North Gauteng High Court in a case called De Beer versus Minister of Cooperative Governance and Traditional Affairs. And the court there basically declared level 4 and level 3 regulations, arguably level 3 regulations were not before the court, unconstitutional on the basis that they were not rationally related to the purpose of the lockdown. The court then suspended the declaration of invalidity to give the minister an opportunity to revise the regulations, taking into account their impact on fundamental rights. However, the academic consensus is, and I've read the judgment myself, that it was a very poorly reasoned judgment, very broadly formulated, with the result that the prospects of being overturned on appeal are probably high, and government has now taken that decision or announced it's going to take the decision on appeal. The other point that I think would be remiss of me not to address is that there have been an incredibly high number of reports of military and police abuses of their powers during the lockdown. This has led the UN High Commissioner for Human Rights' office to include South Africa among those which her office characterizes as a militarized response to the lockdown, and she has criticized the so-called toxic lockdown culture. And it's estimated that over 230,000 people have been arrested for lockdown-related offences, such as, you know, selling contraband nicotine products, cigarettes, or not staying to their home, or not having the necessary permit. And 11 people, all black, have been killed in actions taken during the lockdown. And the most noticeable case of this, and that's enjoyed the most prominence in the media, has been the Collins Causa case, where a resident of the Alexandra township outside Johannesburg, Collins Causa, died allegedly as a result of being assaulted by members of the South African Defence Force for allegedly drinking alcohol in his backyard with a friend. And the result of this was also a court case, in terms of which the High Court ordered that the Minister of Police and the Minister of Defence adopt a code of conduct and operational procedures to guide military and police action during the lockdown, and also ordered that these ministers, that these members of the SADF present are placed on precautionary suspension. The latest in the saga is that an internal inquiry has allegedly cleared the soldiers involved in this event. But the saga is by no means over yet, and one can predict that there's certainly going to be further legal steps taken. But I think that, you know, coming back to your initial point, David, about authoritarianism, I think there definitely has been a strong element in South Africa of a militarized response to the lockdown and this plethora of regulations, some, you know, fairly sort of arbitrary, and that, you know, institutions like the Independent Police Complaints Directorate have not been able to sufficiently check these abuses by speedily investigating cases. I just want to mention that there is now a raft of pending litigation before the courts on diverse aspects, including whether broad-based black economic empowerment legislation should apply to social relief measures, so the affirmative action criteria. There are challenges to the ban on the sale of nicotine products and its relation, you know, does it bear a rational relation to the coronavirus combating measures? There's challenges to businesses such as hairdressers that have not been allowed to open, and so forth. But I think one of the very interesting cases that I would flag for looking at is a direct access case being brought by the Helen Suzman Foundation, which has essentially said that government is under a constitutional duty to enact tailor-made legislation to deal specifically with the circumstances of a public health pandemic such as the coronavirus, and that the National Disaster Act was never intended to deal with a long-running public health saga which is anticipated to last many years possibly, and that essentially puts us in a realm of rule by executive decree. And arguing that we essentially should have tailor-made legislation for this situation, and that this is required by the constitutional duty of the legislature to enact legislation that respects, protects, promotes, and fulfills the Bill of Rights. There are also challenges to the Coronavirus Council, but I think this last case for me raises very interesting issues about the kind of legislation and the role of the legislature in this scenario. So I'll leave it at that. Thanks, David.
Thank you, Sandy. So South Africa has, I think it took a little while, but now the challenges are waking up, and there seems to be a wide range of them. Amita, in India, you mentioned the courts have been quite hands-off in many ways, and in a sense refused to engage much with this. What has the position been in relation to civil and political rights more generally? Have the least restrictive measures been adopted, do you think? And have also, Sandy mentioned the role of the armed forces. Has one seen widespread abuse as well in India in that regard? Let me just unmute you. Let me just see. Are you able to unmute, Amita? Yeah, great.
All right, David, it's like the whole matter of civil political rights has not engaged people to the same extent as, let's say, social economic rights at one level. But what is very critical to appreciate, it's like Agamben has this thing of recognizing what's an exceptional state. And he says that when there is an increase in government power in times of crisis, I somewhere feel that like the Indian situation would need to be understood from that route, in the sense that we've had, even before the lockdown was imposed, the Indian Supreme Court was very actively involved in trying to lessen crowding in prisons. The logic basically was that if this is, overcrowding is something which will make for more people getting infected, it's important that we should be as many people as can be kind of released, discharged from prison should. And they kind of gave a whole range of directives, and this is before the lockdown. At the same time, we've had a large number of civil rights activists, people who have been taking oppositional or dissenting positions in relation to the government, being arrested in this time. So you have, you know, like any kind of other action that you had taken, which was questioning the security of the country, or was doing something which you felt was like you said, that whole phenomena of security of state. So you have a whole range of arrests happening, something as recent, and every one of those people who are being arrested are people who were having run-ins with the government before the pandemic. You know, so it's like these are two kinds of, we had a year-long kind of a protest happening on our Citizenship Amendment Act. There's an entire process by which you're trying to bring in a national register of citizens. People who are in some manner, you could say, be categorized as minorities, have been kind of battling and protesting against that particular legislation. And now suddenly you're finding a two-track happening. At one level, we are saying, let us, you know, like lessen overcrowding in our prisons. And at the same time, people who are civil rights protesters are being sent to prison. And you're saying that this is COVID-19 time and it's not safe and all of that. It's not washing. And the judiciary is the kind of response one would expect from is not coming there. So that for me is one thing which I would want to highlight in what is happening in the Indian situation. And especially because you have not declared an emergency, but you have, you know, like you're just, and the entire dominant discourse is that, okay, we have a health crisis, and we need to be sort of, you know, taking all these measures for the good of our people. And a large number of people buy that logic. You know, it is like you feel, oh, this is not the time to be raising questions on rights. We also have culturally, other than our constitution, a pretty strong duties culture kind of thing. This is a duty time. This is a time where you should be saying, what are you going to do for the, you know, the nation, not what the nation will do for you, that sort of logic. More importantly, which I would sort of, when I speak to you about the social economic rights part and how we've handled that, I would like, there's a lot of pressure on civil society, on people. What are you doing? Don't keep asking what the government is doing. The sort of, as far as loss of civil political rights is concerned, it's again the point I was making in relation to federalism. I would reiterate it here. It's not the same in every part of the country, and it is not the same for everybody. It's like there is a class, religion, caste, you know, all of these things play their own kind of role on how much of your liberty is taken away or not. It's like my driver, when the first day the lockdown was announced, he thought he will just come out and see if there's anything I require and he can help me. And the moment he tried to step out, he was just beaten up, you know, like the policeman just took a baton and beat him up, and he went back home, like necessarily feeling very humiliated by the whole process. But say, if I was to make the same effort, I would just be quietly asked to go back, or even, you know, like facilitated, asking that, is this an emergency, or is it something you really require and stuff. So the whole question of civil political rights and its deprivation doesn't play out the same way for everybody. And if you have then a judiciary which also kinds of is very leaning towards the executive, it's not really listening to the people, then you have, I would say, you know, it's like it's very opaque what's happening. It's very, very opaque. You know, it's like I'm saying, at one point we are saying, oh, we will try as far as possible to lessen overcrowding, to see that, you know, people are not unnecessarily, even detention situations should be reduced. And simultaneously, we are indiscriminately arresting people and saying it's okay. So I do think that, and it's like very difficult because, like I said, you know, you have states in the country which are like total police raj. It's like a total militarization. And there's other parts of the country where people are in active, dialogue with their particular governments as to how this whole question of social responsibility and freedom should be balanced out. So I would say the Indian situation would have to be seen from that place. Thank you.
Many thanks, Amita, and worrying about how dissent is used an opportunity to crush dissent as well in many of these respects. And so perhaps, as you mentioned, a range of issues. Colombia, Manuel, sounded like it has done better in these respects. How has the response been in relation to civil and political rights? It sounds like there's been more of an awareness of constitutional limits. And is the relationship better between the armed forces and the people, particularly, I suppose, given the peace process?
Thank you, David. In Colombia, of course, we have the two big issues, the one related to civil and political rights, and the other debate related to social, economic, and cultural rights. In this part of your question, I will focus on the first one. We have a framework that limits the limitations that the state can establish during any emergency. And these limitations are stated in both judicial decisions and statutes that regulate different kinds of emergencies. Nevertheless, the big question is whether these principles that set the limitations will be applied to the administrative acts that introduce the lockdowns. That's the huge question that is open. What are these principles? Well, of course, proportionality. That includes the less restrictive means test. We have also a basic principle that under an emergency, any kind of emergency, the rights, fundamental rights cannot be suspended. This is a principle of intangibility that concerns every right. There can be reasonable restrictions or limitations, and this reasonableness is assessed through different specific tests. The first one is the measure directly aimed at addressing the emergency? Or is the government using the emergency as a pretext to do things that are not specifically targeted? Secondly, are the measures adopted really necessary? And there we have two kinds of necessity judgment. A necessity that is factual and a necessity that is juridical because there are not other means to do it. Then we have a test concerning the, how to put it, the substantive analysis of the limitation. Is the limitation, let's say, excessive in general? It has to do with the content of the right in itself, not with the rules concerning the emergency. So in sum, the constitution cannot be suspended, checks and balances continue, and rights must be only respected and only reasonably limited or restricted. But what if we go to practice, what is happening in practice, that's another thing. That's another thing. So in practice, what we have is a lockdown that has evolved also in phases. And the lockdown was very strict by mid-March. Very strict means that it covered everybody, and people could not go out of their houses or the place where they live. And secondly, there were 30-something exceptions, but these exceptions were very specific and had to do with essential activities. Go to have access to food, go to financial services, do administrative activities. For example, you're going to buy something, you continue buying something, you have to go to a public notary, these kind of public services, these continued. But of course, in practice, these fares differently depending on a lot of factors. First, do you have a house to live? There are people in Colombia that do not have a place to go into lockdown. So that was a first issue. What to do with those that were in the streets? These were Colombians, but also Venezuelans. So a lot of Venezuelans that came to Colombia to seek refuge from what is happening in Venezuela started to go back to Venezuela, because here they don't have a place to abide by the lockdown. Colombians that live in the street were, in a way, taken care by some state institutions and some private institutions, but in a very, let's say, not complete way. Secondly, those that are informal. In the formal sector, the government, through the state of exception, economic and social emergency, adopted social and economic measures to compensate the lockdown. So businesses received subsidies, help. Poor people that were depending on subsidies that had conditionalities, the government took away the conditionalities, maintained the subsidies, and extended the coverage. I could continue mentioning several measures that compensated the, let's say, the social and economic impact of the lockdown adopted by the emergency. And the Constitutional Court is reviewing that. But in practice, if you are from the informal sector, the state cannot reach you because you are not seen by the state. You work informally. And this has become critical for certain kind of workers. So there have been, first issue, elder that were on a very strict lockdown because of the special vulnerability of people over 70. The lockdown for people over 70 is very strict and continues to be very strict in Colombia. But poor people that are over 70 in Colombia not always have a pension. Very few have a pension. So they have to go out to work. And so we have cases of police abuse, not military. There has not been a militarization, but there have been instances of police abuse against informal workers that are selling food in the streets and that are even elder people. They have been detained, the food they were selling were confiscated or destroyed. Fortunately, it was very bad, police abuse. There have been reactions, and there have been, let's say, a unanimous position saying, police shouldn't work this way. We should understand that there are different impacts of the lockdown that cannot be compensated whether you are informal or formal. Then comes the issue of, let's say, indigenous peoples. There are indigenous peoples that do not live in conditions where you go to lockdown. And this has started to create problems in the Amazon region where, as you know, Brazil didn't go into lockdown quickly, and Brazil, a lot of people got infected very quickly and now is in a very tough situation. This impacted the city in Colombia that the border with Brazil, and the people that live there having then contact with people that they get in contact with indigenous people. So there we have a huge difficulty what to do. And recently there was also a very bad case concerning indigenous that went out to drink. They were drinking in a public space, or they shouldn't, and vigilantes went there and shot them. It was not the police, not the military, but vigilantes that were to implement the lockdown and did so with profiting from the lockdown to attack indigenous people. That what also generated a huge controversy. Then there's a question. Of course, there are a lot of other issues, but I go quickly. Finally, those that are in the prisons. The Constitutional Court declared a state of unconstitutional affairs concerning people that are in the prisons because of the conditions in which they live. This state of unconstitutional affairs has come from a few years ago, and the court is doing the following. One of the first measures adopted by the court after the coronavirus emergency was ordering the government to protect those that were in the prisons. One would say that being in a prison is being in a permanent and very strict lockdown. So you wouldn't be infected, but it didn't happen. The government didn't take the precautions, and inmates started to get infected. And this created huge problems. I will not go into the debate because I've spoken already too long, but there is a huge debate on how to handle the situations in prisons. There have been rebellions, mutinies, very, very, very tough and difficult situations. The big question is whether the Council of State will accept the lockdown that has evolved gradually. And finally, as the lockdown has evolved gradually, the first acceptance of the population concerning the reasonableness of the lockdown in general started to fade. And there has been now movements that try to attack specific aspects of the lockdown. Two of them. First, elderly. People over 70 said that they need to go out, and they are able to decide what risk they should take, and the lockdown shouldn't be extended in such a strict way to them. The lockdown will go until August for over 70, people over 70. And secondly, children. There's a huge debate on what conditions children can go out. And the government adopted a measure that seemed, I don't know how to use it, but very peculiar. It said that children could go out for half an hour if they were under a certain age to play 3 times a week. And so this created that's unacceptable. And there started a debate on whether the government is going too far on limiting basic liberties in a way that is not rational. So we speak of intelligent lockdown. And so the criticism was, this is not intelligent lockdown. This is absurd, unmanageable lockdown.
Yeah, I think it's one of the problems, Manuel, you raise about lockdown is that many of the measures just don't seem to, in many places, have been intelligent in the global south and well adapted to the circumstances. I'm just going to ask our presenters, because we're having such rich answers, but we're not going to have a lot of time for questions. If you look at the chat, there have been some really good ones. So you can have a look when you're not speaking to see some of the things and perhaps address them in your responses, because I don't think we can open to questions without dealing with the question of socioeconomic rights. Socioeconomic rights is really central to the circumstances and situation of the global south. It's also one of the characteristics of many of the constitutions of the global south. And so the question really I have, perhaps starting with Amita, is did socioeconomic rights assist in dealing with economic deprivations and challenges arising from COVID-19? And did the government comply with obligations to realize these rights? Were there significant exclusions in the measures adopted in order to advance the realization of rights? And one of them we saw in the questions is about exclusion of people with limited immigration status, or migrant workers, or people who are not legally in a country and actually aren't able to eat. I heard stories of people actually starving in the middle of Johannesburg because they used to just eking a living and out on the streets, and that couldn't happen. And were the budgetary and human capacity gaps evident in the responses, or were there some successful attempts to address these things? Now, these are big questions. I realize you can't answer all of them. So if we can try, because we want to get a few questions in, 5 minutes each on that, and perhaps starting with you, Amita. I'm going to unmute you. Just unmute. Possible? There we go. Great.
All right, David, I mean, in fact, for us, if there has been one competing discourse along with the pandemic, it has been this whole question of economic deprivation and the people who are being affected by it. Despite the lockdown, because of the fact that there was a large number of people who didn't have a roof over their head, and if they were what we call as, like people from within the country, but from a different state. It's like if I am working in the west of the country and my original home state is in the east, and and with the lockdown, I have no place to stay because the place where I worked was the place where I stayed, and my workplace has closed. So you had the migrants starting to walk back basically because of the fact that there was no other arrangement of transportation, and there was no arrangement in the first place wherein, like you could say, okay, till the lockdown is there, you can be staying here and we will be making arrangements for your, food and stay and whatever else. Kerala did it to some extent, which is the state I've been referring to on a constant basis. And we had in the first, the first set of petitions which were filed in the Supreme Court came for these migrant workers to be saying that, listen, here is a whole range of people who are walking back because they have nothing here, so you should do something about it. And you had and in fact, also you had large number of people congregating at, places, at bus stations, at railway stations and other places, because there was a talk that the state is going to be making arrangements for you to go back home. And so you had the Solicitor General of the country going into the Supreme Court and saying, oh, no, this was all fake news which caused for these people to congregate. Otherwise, there is no real problem. The second round, they landed up coming and saying, oh, we've sorted it all out. You actually had affidavits being filed saying there isn't a single migrant worker on the road when the truth and the facts was contrary. You had cases being filed where you had petitions, you had affidavits filed from civil society organizations saying that the ground level situation is so bad. But the government was saying otherwise, and the court took the line in the first instance that we're not going to listen to private reports. If the state is saying that all is well, then all is well. You're not really giving us, I'm just saying that you're not really giving us what is the factual situation, not recognizing the fact that if there is a lockdown, from where is anybody, you're just giving us newspaper reports, you're not saying anything more. But if there's a lockdown, from where do I hold an investigation? Necessarily, this would be the way it would go. So you could say till March, April, that's the way it went on and on. You had some high courts who took a more proactive line, who insisted that the government has to make place for people to stay. If you're going to send them home, you are going to pay for their transportation. All of those orders came from specific high courts in the country, but the Supreme Court of the country was like taking this total, we believe the government, they will not be saying any, like if they are saying what they are saying, then that's the truth, and you're just coming here and trying to badmouth. The apex court got such a lot of, you could say, bad press, and a lot of people started to feel that what constitution and what Supreme Court and what judicial review, if this is the manner in which the court is going to be addressing questions of the infringements of rights of people. And so you had, and I'll kind of close with that, I'm conscious of your time limitation. So it's like what you landed up having, and that's the recent development in India, is that you had, it was more or less unprecedented that retired judges, large number of senior advocates, wrote to the Supreme Court of the country saying, what the hell are you guys doing? What are you doing? This is the time when you are needed, and actually providing for that this is the kind of distress that people are in. And from there, the Supreme Court sort of started a suo moto, trying to look in and making orders. I'll make one last point, David. What has also happened at the same time is that while the state has been doing more posturing than real work, you've had a large amount of civil society initiative. A lot of people are feeling horrible about the fact that so many people are in such a bad state. We've never had this level of philanthropic kinds of interventions in India. There is also this entire thing that you could say that in doing these philanthropic interventions, whether we are also more, we are contributing to the state being taken off the hook because someone is doing it, or it is like, but at the same time, it's this fact of that people should not be hungry, and if someone is in such a miserable state, we can't possibly allow it to happen. If somebody wants to go home, then we will arrange for transportation. That kind of thing is simultaneously happening. Whether it's for good, whether we should have been holding the state accountable and only providing for palliative aid, or we should have done it otherwise, remains a question. But this is where we are in terms of social economic rights. I mean, there's a lot more happening, but then you have time, you know.
Absolutely, and if there's another chance, come in on anything.
I'm conscious of the fact that I was watching my clock.
Absolutely, thank you so much, Amita. And perhaps turning to Manuel, you did start talking about some of the measures. How have socioeconomic rights functioned in Colombia in these contexts? Have there been an influx of tutelas, these individual actions for protection of individuals? Have the courts engaged more structurally on these things, or has it not really reached the courts and it's really been in the government's hands?
Yeah. So concerning socioeconomic rights, which are protected in the Constitution, the main instrument has been the state of exception. So the state of economic and social emergency that was declared also by the executive, and the legislative decrees adopted had been sent automatically to judicial review by the Constitutional Court. So this is the main judicial control. There have been many socio-economic measures adopted through the state of economic and social emergency. Over 70 decrees in the first emergency that could only last 30 days. There is a temporal limit for state of exception. And the state of exception was declared again, and we are over 40 new decrees. So it's very difficult to summarize all of them in 5 minutes. But in essence, what the government has tried to do is to regulate first subsidies, as I mentioned, subsidies aimed at poor people, and also subsidies that help businesses to survive, or regulations that help businesses to manage and not go broke. This is the first kind of measures. The second kind of measures have to do to access to services which are very important for the protection of social rights. So, for example, access to water. There was a measure adopted that did not allow a public utilities company that provide water to disconnect people that couldn't pay the bill. So it was forbidden for these companies, being state or private, to disconnect those that didn't pay. So water should flow. Also measure that where the public utilities couldn't reach the people, so there was a charge of bringing the water through big car tanks. So water would be accessible to the people. These were the kind of obligations so that the right to access clean water was preserved. These were the other kind. The third kind are measures that allow for ordinary matters to be handled in a way. Let's say, should the owners of a restaurant pay the rent to the owner of the building where the restaurant is functioning? All these kind of things were addressed. The most interesting ones are the decisions of the Constitutional Court, which are starting to appear, that address this kind of measures. So, for example, access to water. The decree said that if someone had a fraudulent connection to the public utility, as happens, people connect without paying and using fraud. Usually, poor people in poor areas where they need access to the water or to electricity. There can be a disconnection. The decree said that this could continue. The court said no. Even if there was a connection based on fraud, the right to access water prevails. And therefore, there is no way to disconnect, even if there was fraud. Afterwards, the public utility company can charge and seek ways to recover the money, or the state can put some money to help these public utility companies, but there cannot be cut from public utilities. So there are these kind of decisions that are intervening in a specific aspects of the decrees, but in general, the decrees have been declared constitutional until now. There are few decisions, not more of 10, and we have over 100 emergency decrees. So we have to see. The big questions concern some taxes. There was a solidarity tax imposed by the emergency legislation on those public servants and pension owners that receive high salaries or high pensions for 3 months. So there's a debate in this whether this can happen or not. There's a huge debate concerning the transfer of those individual workers that are in the pension system based on capitalization to the pension system that is managed by the state and does not work on savings. The government intervened and said, those that do not have enough savings to access a pension must move to the state system, and the state will subsidize these pensions. There's a huge debate on whether this could be done or not, and who is really benefiting. Some say this is a good measure because it will protect those that have access to a low pension that goes near the minimum salary. That's a good measure. Others say no. This was a measure to really use the capital that was saved to help the state have enough liquidity to pay other pensions. So it was not in the interest of the poor, let's say, that have a minimum pension, but in the interest of the state having cash and alleviating the burden of the private system that would have to put money to subsidize the pensions of the poor. So it's a huge debate. The Constitutional Court will have to decide on that. So I don't have enough time, but there are a lot of measures that are all in the midst of a constitutional debate. Tutelas are being invoked gradually, but mainly against the lockdown. So specific sectors using tutelas against the lockdown, and no decisions yet. And as I mentioned, mainly those that are over 70 years old.
Thank you so much, Manuel. And as I think many of us who know the jurisprudence of the courts and some of the issues, Colombia is often a leader in these respects. And for example, preventing disconnections in case of fraudulent connections and things like that. So it seems like a fascinating space to watch what's actually going to happen. And last but not least, Sandy, perhaps you can address, you have, of course, a global picture as well as being on the Committee on Economic and Social and Cultural Rights in this respect. So please feel free to reflect. But also, of course, South Africa has faced a grave situation as well in this regard. And perhaps you can address socioeconomic rights in the context of South Africa in COVID.
Thanks, David. And I'm going to not be able to cover all the measures taken, so I'll try and focus on the most significant and also the groups that have been most vulnerable and least excluded by the measures. And I think some of the questions that have been coming through on the chat have already alluded to those. So on the 21st of April, the president announced a 500 billion rand social relief package to deal with the consequences of the pandemic. That is about 30 million US dollars, if my maths have me right. And essentially, there have been a range of measures taken in this regard. Some are targeted more to the formal sector, for example, the temporary employer relief scheme, which allows workers to claim wages for workers that are going to be laid off or temporarily unable to be paid. There have been problems with this because many workers, such as domestic workers and farm workers, have not been registered, and also initially it left it in the hands of employers to claim the benefits on behalf of their employees. And that is now subsequently, through interventions by the Casual Workers Advice Office and others, their definition has been changed to allow workers who should have been registered but haven't been to claim, and also to allow workers to directly access the TERS scheme. Another major mechanism has been relief, debt relief to small, micro and medium-sized enterprises. However, the difficulty with this scheme is that the conditions are that you are formally registered with our Companies and Intellectual Property Office, that your tax records are fully up to date, and that you must be 100% South African owned, and over 70% of your workforce must be South Africans. And the result of that is that many informal sector businesses, including businesses run by non-nationals, have not been able to claim. And this is a major problem because it's estimated that the informal sector contributes about 47% of jobs in South Africa. So the exceptional vulnerability of this sector and not being catered for by some of the relief measures. And then one of the major measures that have been taken has been for unemployed people without access to an existing non-contributory social grant, has been a special so-called COVID-19 relief grant, which is in the amount of 350 Rand, and the idea is it will be payable for a 6-month period. This grant extends to South African citizens, permanent residents, and refugees. Excluded are asylum seekers and people on special immigration permits. And Chanel mentioned this in the chat, but there is essentially an application to court by the Scalabrini Center, who advocates for the rights of refugees and asylum seekers, to rule that this complete exclusion of basically asylum seekers, permanent residents, and non-documented nationals is unconstitutional. I think the problem with this scheme also just has been implementation. Over 5 million applications were made for this particular grant, and the process of vetting and approving and paying has been painfully slow, with the Department of Social Development only being fully staffed from the 1st of June. There's also been top-ups to our existing social grants, for example, small top-ups, and with the child support grant, which is acknowledged to be a major poverty alleviation measure and particularly well targeted to the informal sector. Government said it would increase the grant initially by 300 Rand and then 500 Rand for the period of June to October. But then subsequently it emerged that the fine print was that instead of being paid per child, as is the usual rule, it's now only going to be paid per caregiver. And this substantially dilutes the poverty alleviation, mechanism of this program. There's also been a huge issue of hunger and food insecurity through the pandemic, with the collapse of many informal sector businesses as well as waste pickers and activities. And government promised to undertake a massive distribution of food parcels. What has aggravated the situation is through the closure of the schools. The National School Nutrition Scheme, which feeds 9 million children, also closed down. And this has created large reports with civil society reporting that close to half the population is in need of food relief. Reports are that essentially that the government distribution system is not reaching everyone in need. There's a lot of civil society actors are stepping up to the table. There's also been some concern that government is trying to control the process through a coordination and permit system, although this seems to now have been dropped. But there are a lot of issues with food security in South Africa and with access to sufficient food. I have a range of issues also that have come to light around housing. I could just mention in that regard that there was initially during the hard lockdown phase a complete moratorium on evictions. With the moving to stage 4 and 3, it is now permissible for the court to grant an eviction order, but the eviction order cannot be executed. At the same time, there have also been reports that, in fact, this has been ignored in some locations in practice and that people are being evicted. And there's also been concerns about a de-densification program, which the Department of Human Settlements has announced to try and de-densify informal settlements to make them more appropriate to social distancing. And there's been a lot of criticism also of these measures, with some civil society organizations saying this is basically going to amount to a veiled eviction of people. So I think in summary, there's a lot of issues around education as well, and the extent to which the move to online learning, the closure of the schools has aggravated existing inequalities brought about through the digital divide and unconducive. Despite the measures taken, the pandemic has really magnified the pre-existing issues of poverty, terrible socioeconomic inequality, unemployment, and the precarious position of many low-wage workers, and workers in the informal sector. And I think the challenge as we move to lighten up with the lockdown and we move to a sort of post-COVID scenario is how these short-term interventions can translate into longer-term programs, such as potentially a basic income grant. There's been much debate about reinvigorating the wealth tax, of introducing a wealth tax in South Africa, which has received a lot of support and buy-in from academics and civil society. So I think I've left out many issues, but I think I'll let it rest at that. Thanks.
Thank you so much, Sandy. So we've heard a really fantastic encapsulation of many of the issues around various constitutional dimensions in the Global South. Now, we were going to have like a half an hour for questions, but given the complexity, we are we won't have that amount of time. But I wanted to, I think some of the questions have been addressed already by some of the panelists. You've been seeing them in the chat. And also, I think in the concluding statement, I'm going to ask from our panelists, some of them will also come out because they relate to the reflections. I think we wanted an opportunity for you to comment a little bit comparatively as well from what you've heard, perhaps on some of the cross-cutting issues that may have come about. And I could pose, two questions perhaps. Do you think COVID-19 will change your country? That's, I suppose, specific to your country from a constitutional point of view. And hearing the others, do you have comparative reflections about what constitutionalists need to bear in mind in designing provisions relating to public health emergencies? I think in relation to the first question, there was a question in the chat about universal basic income, for example. Is that something that's coming about? Is there going to be a real guarantee of a minimum call finally, for example? And in relation to the second question, there was Ruby Ziegler, for example, asked about whether the design of state of emergencies has not really been well designed to address health crises, where they've been focused on peace and security, for example. So these are some of the issues. I leave it to you to reflect on what aspects you would like to. And so I go to Amita first. Amita, would you like to give some closing reflections?
The way I see it, I mean, I'm listening to the panelists as well as looking at the questions which have come. I think I noticed that both especially in Colombia, but also in South Africa, you find that many more questions of entitlements are going to courts, are being looked at by policymakers to be trying to see, okay, how are we going to resolve matters? We are much more at, like negotiating with governments in relation to executive instructions and to see what is it that you could, where is it that you could be accommodating people? What kinds of, what kind of relief that you can be putting forth? Our numbers have, like in terms of absolute numbers, India has now crossed both Spain and Italy and is like in the top 5. So it's in terms of the number of infections that you're battling with is huge. Our death rates are not that bad. I mean, we are still at a 2.5%, and that's an okay kind of thing. But in terms of how is it that we need to be starting to thinking on these issues? I think the whole question of migrant workers, the whole question of labor rights is very much in the forefront of discussions which are happening in our country. And the other thing which seems to be happening, and that's wherein I at least I've gained very tremendously from listening to the other panelists, is that there is a certain amount of vulnerability which has become common across society. Everybody is feeling vulnerable in different kinds of ways. People who felt that, they were at that strata of society, that economic want would not be something they would need to address. Suddenly that's become an issue for them. Whether this will result in more empathetic public policies and more inclusive kinds of interventions, or will it be that you'll just raise the barrier and you're pushing out other people and just want to protect yourself? I really can't say which way we will go. I'm only, because I had sort of said to you when I spoke in terms of unprecedented civil society intervention and a lot of philanthropy coming to the fore, whether that will seep into bringing in a certain amount of empathy into public policy and ask us to be adopting more inclusive interventions and not just go and, plan an entire lockdown for the whole country, forgetting that you have 50% of your workers as in the informal sector, as migrant workers. What exactly are you going to do for them? You didn't think about it. And if we are going to be operating, it also sort of speaks in terms of more even-handed kind of development, so that people are not rushing to other places just for plain livelihood. These are some of the concerns and queries which are coming forth. Constitutionally, I think what's happening for us, David, is that we are going through this entire stage of a certain amount of skepticism and disaffection on whether we could possibly be getting anything through a liberal constitutional discourse, or do we really need to kind of rethink a bottom-up way of looking at our constitution? And I think some of the instances and examples, especially what Manuel was talking about, possibly could be, could be the kind of reasoning that we need to be developing, is how I would want to be looking at this conversation, as well as the conversations we need to have post the press.
Thank you very much, Amita, for those very interesting reflections about the future and what we're learning from this. And so perhaps I could turn to Sandy to give her thoughts.
Yeah, so thanks, David. I mean, I think if I've painted an overly gloomy picture, I just want to say, I mean, I think the two aspects that South Africa did get right, and, you know, sort of comparing with some other big countries around the world, is, you know, the fact that we responded early and seriously to the pandemic, and by all accounts, this has had, you know, a life-saving impact. And that also that government has been very responsive to scientific advice and has surrounded itself with a whole panel of experts led by one of the top epidemiologists, you know, in the world to guide its responses. So I would say that's the positive aspect. The negative aspect, and that I sort of see, you know, some similarities between what Manuel and Amita presented, is that, you know, and you alluded to it, David, was this sort of essentially use of emergency powers through ordinary means to affect far-reaching limitations on fundamental rights. And, you know, particularly in South Africa, I think our response has been over-militarized, and there's really been insufficient institutional safeguards against abuses. And Amita was talking about, you know, sort of a need for a new politics, a more kind of bottom-up feeling, you know, approach. And, you know, I would think that a strategy strengthening the participatory dimensions of our constitutional discourse, so that we rather focus on issues like community education, engagement, partnership, than this top-down enforcement militarized issue. Because as Zukiswa Pikoli said in an, you know, which really struck me in an article this morning in Daily Maverick, we're dealing with a public health crisis and not a safety and security crisis. And, you know, that sort of just brings me to the other point which was raised by Ruvi in the chat, that I do think that we probably need some sort of more tailored legislation to deal with a situation that's not a sudden disaster where you need immediate mobilization and maybe a short period of executive rule for a period, but that you're dealing with a long-term chronic health issue. Many reports say Corona is going to be with us for a number of years, and I think we need measures to safeguard that the lawmaking to deal with this, you know, especially the far-reaching limitations to rights, remains firmly in the hands of legislatures in this situation. And then I've already, in conclusion, alluded to what I said earlier about the deep inequalities which the pandemic has just magnified of race, class, gender, disability in the South African context. And the challenge for us is really in the context of limited resources, highly constrained budgets. South Africa, for the first time, is going to be seeking a loan from the international financial institutions to help it cope with the pandemic. How can we do this in a way that also, builds a new economy and a new inclusive society? Thanks, David.
Thank you so much, Sandy. That again, very fascinating, and again, also some overlapping themes coming out from India and South Africa. Manuel, what are your thoughts in comparative experience as well as for the future in this regard?
Yes, thank you, David. I think that the pandemic has created a huge challenge for constitutional law in general, and also for Colombian constitutional law. The first big challenge for me is how the normal workings of institutions and society are paralyzed. The Constitutional Court, for example, in Colombia, had to work virtually. Congress had to meet virtually. Civil society organizations could not go out to do whatever they thought they should wanted to do, either protest, either argue for some rights, either argue in favor or against some policies. So democratic processes and institutional checks and balances were in the brink of being totally paralyzed, halted, with an argument that at the beginning was accepted. It was, if you go out, you may die. Or if you go out, you may put other people at risk of dying. So it was such a strong argument that at the beginning, like, society and institutions stopped. In practice, this is a huge challenge, because let's hope there is a vaccine, let's hope there is a good treatment. But if not, and the opening leads to second or third waves, we should find ways to allow democratic processes and institutions to work. I'm glad that the Constitutional Court decided to work virtually and control the executive. But for the Council of State has been more difficult. And the Council of State has the mission of reviewing the administrative acts that establish the lockdown. Second big issue is how to give reasonable weight to new experts that appear. In Colombia, we had a battle of economic experts against constitutionalists, mainly concerning social rights. Okay, now the new issue is there are new experts, the epidemiologists and the doctors that said different things. And we do not have anything. No, it's totally new for us how to approach the power of these new expertise that suddenly said, you have to lock the country. You have to lock down, otherwise it would be tragic. How to handle that? Of course, this applies to Colombia, but also to the Imperial College in the United Kingdom, who had certain estimates and then changed the estimates. The estimates of the Imperial College for Colombia were so tragic that the lockdown was in part justified by what was predicted then. So how to establish limitations, political deliberation, democratic principles to the exercise of the power of new experts that again, huge influence in the executive. Third issue, how to balance the implications of the protection of life and health through lockdowns and the huge impact on life and health of this lockdown. So in Colombia, we finally moved to a debate in which the question was not the economy functioning against protecting health and life. It was clear that if there was not a balance, being a country with informal workers, with people in poverty, with difficulties in access to food, well, all that we have in the global south, if the lockdown is prolonged in not an intelligent way, to use the catch expression, more people will go into poverty, more people will not have access to food, more people will not have access to health. We have cases in which people do not go to the hospital because they fear that in the hospital they will have the coronavirus, get infected and die. So we have to find a better constitutional category to order what is happening. And we are trying to build it, and we don't know how to do it yet. We are trying. Of course, there are political debates concerning, and it's interesting, universal income. And it's mainly from leftist parties that have raised the issue of not going by subsidies, grants, and specific measures, but have a general basic income for everybody, or at least for certain sections of the population. This is very unlikely in Colombia because we don't have the budget for that. And finally, the important point of the adequate instruments. It's clear that although we had a lot of emergencies in Colombia, a lot of crises, a lot of problems, the instrument used to declare the sanitary emergency was a very old statute that is not suited to manage the dimensions of this pandemic. So it caught us for surprise. We don't know what is going to happen as the lockdown continues and we go into phases with more liberty, and the Council of State and tutelas start to address that. But this is also a huge issue. In the end, in general, I share what Sandy and Amita has saying, that we need to reinvigorate the democratic processes under the pandemic. It's not only a question of checks and balances, but how democratic processes continue to function. And this is a huge challenge, not only for this kind of pandemic, but I think for the future, as there are many challenges for constitutional democracy in the world coming from phenomena that are globalized and that are difficult to handle at the state level. And this leads to my last point, is whether we can, as the global south, in these situations, increase our voice in favor of addressing these global issues in a global way. Because what I fear to see is, despite certain initiatives, the vaccine will be distributed in a way that will not be fair, in spite of some initiatives that want to make it fair. Access to treatments, access to food, access to basic services, all these exceeds the capacities of limited budgets of most countries of the global south. So it's a huge challenge for international cooperation. And I don't know if the global south will manage to speak with a reasonable voice. I am not seeing that, at least in Latin America. We have Brazil, Mexico, and other countries in a totally different perspective. And so it's a huge challenge. It's not even a desire, it's a challenge. And so thank you. It has been a pleasure to participate in this conversation.
Thank you, Manuel. You raised the issue of that. In a sense, COVID seems to have pushed people back into their national borders, very protectionist in some ways. And it's interesting how, and we had one question from Elena about the need actually often in these crises to internationalize, to work together, to find a way through. And I think you, Sandy, and Amita have really provided us with a window into these three societies, which put together provide a really wider picture in which we think we can see, on the one hand, a very human challenge, a challenge about health, about life, and yet at the same time, the structures of constitutional democracy remain absolutely crucial. That actually going beyond and trying to circumvent the various protections in the Constitution don't help. Courts being involved, having checks and balances are absolutely critical at these times. Maintaining a sense of the rights, the civil and political rights that matter, remain crucial. And then, of course, the socioeconomic issues, which have bedeviled many of our societies for so long, become more pronounced. And the question is, how are we going to move forward into a different world after? I think that's many people are asking that. Health crises don't necessarily make us better, but it is a choice. Do we become better? Do we think of different ways of being? And I think for those of us involved in constitutional structures and rights advancement, we can think of what needs to happen next in order to advance our societies, to address these kinds of crises in future, and hopefully build better lives and better futures for all the people and other creatures and the environment more generally in our countries. So it really has been a pleasure. Thank you so much. I know people have been saying thank you. If you want to put jazz hands or just put in the chat, thank you to the speakers, please do. I've seen a number of people have already done so. And we really appreciate your time. Thank you everyone for taking part, for listening. We're going to continue. We do have further seminars. We're actually going to deal with a very fascinating case which happened during the crisis in Malawi, which declared the presidential elections null and void. The Constitutional Court and the Supreme Court of Appeal, that will take place. We're going to have a seminar with 2 illustrious speakers next Friday, the 19th of June. Please be in touch with us if you're interested in joining for that at lunchtime, South African time, 1 o'clock to 2:30. And we will also continue some of the themes that have emerged here have certainly stimulated me to want to engage with some of the other issues. So a real pleasure. Thank you so much to our presenters, and thank you everyone for your participation.